Good morning, everyone. Welcome to Print Industry Midwest Smart Cafe. We're excited to have you all here today for our Smart Cafe on hot topics with Tom Revnew. And what we're going to do first is have our sponsor, Jacob from Gravy. He is going to just do a brief introduction to what Gravy does. We're excited to have them as a member and a sponsor of our Smart Cafe events. And go ahead, Jacob.
Awesome. Thank you, Chris. And thanks for allowing me to take a little bit of everybody's time today. Lucky for you guys, you won't be hearing an hour and a half of insurance talk, so I'll keep it very brief. Gravy, we're headquartered in Minneapolis, an insurance company there. We partnered with Printing Industry Midwest in providing you an alternative for your group health insurance. What Gravy is doing that's a little bit unique to the industry is really offering a plan design and an option that we feel brings a lot more value across the board to an entire employee population. Now, what that means is Gravy looked at really the consumers of health insurance. And so we really wanted to focus on employers and employees both and understand what are some of those pain points that they're having with their traditional health benefits. And maybe some of these resonate with you and your teams. So members were frustrated with the lack of coverage on common healthcare services, primary care, urgent care, labs and imaging, generic prescriptions. So really that experience of kind of being nickeled and dimed every single time you go use your health insurance. You pay your premium entry each and every month. Where's that true value coming in? We also really heard from the consumers the confusion that comes around traditional health benefits as well, right? So having to hit a deductible, having to then pay a percentage to reach another number. And so what Gravy really wanted to do was really knock down some of those barriers to entry for the consumers of their health insurance. And so what Gravy's done is created a plan design. It's called Comfort, where there are no costs for, again, some of those common healthcare services, primary care, urgent care, labs and imaging, generic prescriptions, online care, where employees, again, will be able to get more value across the board as opposed to what they're seeing in a traditional plan. Now, what does that mean? What are employees responsible for? Employees will have what is an out-of-pocket maximum that, of course, will work with your broker and you as an employer to understand where do we want to set an out-of-pocket max limits. Employees will be responsible for more of those larger uncommon items that you'd be putting spend towards in a traditional plan. So inpatient stays, surgeries, hospitalizations, but know that over 85% of what is a typical spend for an employee will be covered at no cost. So the other part of this, what Gravy brings to the table is really a very unique support experience. You have licensed health insurance professionals that are there to assist your employees. We also partner with regional and national PPO networks. So Preferred One, they're in Minnesota, South Dakota, North Dakota. We also partner with Aetna and Cigna on their most large, broad national PPO networks. So your employees have little to no disruptions when they're looking to access those same providers that they're seeing today. So if interested in having a conversation of exploring your health benefits, please reach out to representatives there at PIM, and we'd be happy to have that conversation with you. So again, I appreciate the time today. Really nice being here. And I believe I'm handing this back over to Tom for the bulk of your guys' conversation today. So again, thanks everyone.
Thanks, Adam. I'm going to just share my screen here for a moment. So bear with me for a second. Okay. Thanks, Jacob, and thanks to Chris and Ben, as well as others at the Printing Industry Midwest for having me speak today. And today I'm going to speak about hot topics in labor and employment law and talk about some of the changes that have occurred under the Biden administration and how they will impact you as employers. I can tell you that anytime there's a change in administrations from a Republican to a Democrat or a Democrat to a Republican, there's always a significant pendulum switch, or certainly there has been over the last several changes in administrations. And of course, the Biden administration is no different than what happened under the Trump administration, as far as the pendulum swinging one direction or the other. And so today, I'm going to spend some time talking to you about changes in the federal agencies. I know everybody is probably COVID tired, but I'm going to spend just a little bit of time talking about some COVID updates, or at least tell you where we're at as far as what's going on within the administration for COVID updates. I'm sure a lot of you are, if you are traveling, you're probably very excited to travel, go to the airport and jump on a plane and not have to wear a mask for a very long time. I'll talk a little bit about what's going on in Minnesota, some proposed federal legislation, and then I'll conclude with talking about non-solicitation, non-competition agreements, which I'll tell you, I've seen a significant uptick in litigation or disputes over non-compete agreements. And I just want to touch base with you with regard to what you should be looking for. So jumping right into the federal agency updates. And by the way, I should tell you that please feel free to ask questions as we go along. I'll try to monitor the chat box for any questions that you raise. I know Chris is also taking a look at any questions that you raise in the chat box as well. I'll try to answer your questions as we go along, but if I don't, I'll certainly be looking at the questions at the end of today's session as well and try to answer your questions. With regard to what's going on within the federal government and the federal agencies, the first is the Department of Homeland Security. And many of you are well aware that with regard to the Department of Homeland Security, where it impacts you as a business or as an employer, is you're required to complete the Form I-9 forms when somebody commences employment. Now, the good news is that what we are seeing as it relates to the Department of Homeland Security, and it's referred to ICE, the Immigration Customs Enforcement, ICE audits have decreased dramatically. And under the Trump administration, we saw a significant increase in audits of an employer's I-9s. And under the new administration, we're seeing a significant cutback on I-9 audits. In fact, President Biden indicated at the very beginning of his employment that he intended to end workplace raids. In other words, where Homeland Security would raid an employer's business under the belief that particular business had employed or was employing a significant number of unauthorized workers. And so Biden said it was his intent to end that practice. And of course, shortly after he took office, we also saw that ICE announced that its enforcement and removal efforts would be focused on threats to national security and border security, and not on auditing I-9s. So many of you may wonder, well, what do we do with I-9s? And obviously, it's still the law. You still have to have I-9s completed, and you have to have them completed in a timely basis. And you can still be subject to fines and penalties. Homeland Security is still doing audits. They're just not doing as many as they've done in the past. And so even though the Biden administration is more relaxed on the Form I-9s, I still tell clients on a regular basis that doing internal I-9 audits is still a good idea. It's still a good idea for you as an HR representative or a business owner. If you have not done an audit of your I-9s in the past, I still think it's a good practice to do so, to make sure that your I-9s were completed properly, that all the blanks on the Form I-9 were properly completed, the information was filled in. Because keep in mind that if they weren't, you can be subject to fines just for what are referred to as technical violations. And I've had clients who have been faced fines of up to $500,000 because their I-9s were not completed properly. Additionally, to the extent that you're working remotely, and I think this is, there are fewer and fewer employers that have employees that are working remotely. Just as a reminder, the deadline for completing I-9s remotely ends April 30th of this year. That has not extended. And what that meant was during COVID, an employer could review the I-9 documents via remote access. And then once somebody came onto premises, that you'd have to look at them within three business days after in-person operations resumed. Obviously, if your business is not remote, you have to have those I-9s completed within 3 days of the person commencing employment. So ensure that your I-9s are completed properly from the beginning. Other changes going on with the federal agencies, the Department of Labor. And what I would say is there is a significant issue out there. Some of you may remember that under the Trump administration essentially was looking for a way to make it easier for businesses to classify individuals as independent contractors as opposed to employees. And essentially, shortly before he left office, the Department of Labor announced a final rule that essentially adopted what was referred to as the economic reality test. And that was to take effect on March 8th of 2021. Well, when the Biden administration came in, they withdrew that final rule. And the withdrawal of that rule is being challenged, but essentially the Biden administration is advocating for what's referred to as the ABC test. And the ABC test is used in California. And of course, for those of you who are familiar with California law, you probably don't need me to say anything more than it's extremely employee friendly. And essentially the ABC test defaults all workers as employees. So the presumption is that all workers are employees unless the employer can rebut that presumption by showing that the worker is free from control and direction of the employer, that they perform the work outside the employer's usual business, and they're customarily engaged in an independently established business or trade. Bottom line, under the Biden administration, essentially what they're saying is if it looks like a duck, it quacks like a duck, well, it is a duck. In other words, if it looks like an employee and acts like an employee, then it is an employee. And I just reference this because I know a lot of businesses use independent contractors, and sometimes it's just one individual that they have classified as an independent contractor, whether it's an accountant or somebody within the office. And just be aware that under the Biden administration, the presumption will be that that individual is an employee and not an independent contractor. So you might want to, if you have individuals that are independent contractors, you might want to look at that a little bit more closely under this new administration. Additionally, a couple things to keep in mind is that if you are a federal contractor, and I believe there may be some federal contractors on the line, that as of January 30th of this year, under all new federal contracts, at minimum, you have to pay $15 an hour to workers who are performing work on or in connection with federal contracts. And starting in 2023, that rate, that $15 an hour, will be increased based upon inflation, which is required to be published in the Federal Register at least 90 days prior to the new year, and it'll also be posted on the Department of Labor's website. And so you're going to ultimately, if you are working under a federal contract, you're going to have to decide or determine who is actually performing work under the contract. And that could be anybody who's necessary for the performance of the contract. And so that can be pretty broad. And that could be, a payroll clerk who is processing the payroll could be considered an individual who is performing work under the contract, and they would have to be paid the minimum wage of $15 an hour. As a federal contractor, also keep in mind that there are new affirmative action plan certification requirements that are coming up with the OFCCP. And so if you're a federal contractor, you have to have an affirmative action plan. And by June 30th of this year, federal contractors must certify via the OFCCP online portal whether they have developed and maintained an affirmative action plan. That certification process began as of March 31st, and obviously is currently open. So again, if you are a federal contractor, make sure that you're in compliance with your affirmative action plan requirements and your certification requirements. Perhaps the agency where I see the most significant changes taking place that will impact employers is the National Labor Relations Board. And I could spend well over an hour just talking about the changes within the NLRB and how that's going to impact employers. But bottom line is, if you look at who the current members are of the National Labor Relations Board, you essentially have 3 Democrats and 2 Republicans. And what you need to know from that standpoint is, now that the NLRB is democratically controlled, you're going to see a significant number of pro-employee decisions being issued. 2 of the Democrats, Gwen Wilcox and David Crowdy, are former union attorneys. Lauren McFerrin has been on the board now, I would say at least 8 years, if not longer, and she's a former staffer for Kennedy when he was alive. But bottom line is, you're going to see a lot of pro-employee decisions that are coming. And you're going to see notable decisions that were issued under the Trump administration that are going to be reversed, or that they're looking to reverse. And one of them is this Apogee retail case that was decided by the Trump board in 2019. And some of you may remember, under the Obama administration, the Obama board essentially said that employers can't require employees to maintain confidentiality in workplace investigations. Under the Obama board, essentially, there was a case where an employer was involved in a investigation into sexual harassment, and they were interviewing a number of employees, and they asked the employees to keep that investigation quiet, not to talk about their interviews with their employees, in part because they wanted to protect the integrity of the investigation. And the Obama board said an employer had no right to direct employees to keep the investigation confidential, that they were interfering with their protected concerted rights by preventing them from talking about the investigation. And so that case was the law of the land for, I would say probably 3-4 years, until the Trump administration reversed it and essentially said employers have the right to require employees to maintain confidentiality in workplace investigations. And what we have heard is that the new general counsel, an individual by the name of JenniferAbruzzo, has essentially said that they are looking for a case where they can reverse the Apogee case and go back to this old standard that you can't prevent employees from talking about an investigation while the investigation was going on. Another case that the Biden board will be looking to overturn is a Caesar Entertainment case. And in essence, in Caesar Entertainment, they had overruled the decision by the Obama board, where the Obama board said that employers could not restrict employees' access to emails for purposes of engaging in union organizing or collective bargaining. And Caesars Entertainment Corp reversed that case and said that employers have a right, general right, to impose non-discriminatory restrictions, including outright bans on the use of employer-owned IT systems for non-work purposes. We're likely to see a reversal where the Biden administration goes back and says employees have the right to use email for protected concerted activities, such as engaging in union organizing or what have you. Other notable decisions where the Biden administration is looking at reversing past case law, and in particular case law dealing with the Trump administration, is essentially eliminating confidentiality clauses and mandatory arbitration agreements, revisiting what the standard is to determine whether an employer work rule is considered unlawful. And I will tell you, under the Obama board, as an attorney, it was really difficult for employers to determine what the board would consider to be lawful versus unlawful. The Trump administration clarified that and essentially adopted a standard that most employers could follow. And the Biden administration wants to go back to this vague standard, which ends up being a gotcha for employers who draft employee handbooks that have work rules that are intended to have legitimate business reasons, but where the board will stretch their imagination to find that it precludes employees from engaging in concerted activity. Additionally, the NLRB is looking at essentially expanding the damages that could be available under the National Labor Relations Act. So right now, if somebody is terminated from employment and they're wrongfully terminated under the NLRB, essentially the board can order reinstatement with back pay. The NLRB now, for the first time, seeks to expand the damages available to consequential damages. And so in essence, assume somebody loses a job, and as a result of losing their job, they lose their house because they couldn't make their house payments. Essentially, they want the employer to pay for the loss of the house as part of the consequential damages. There's a whole host of other areas that the NLRB will be looking at. It's what is the appropriate bargaining unit. They will try to impact how an employer does an investigation. Johnny's Poultry was a way in which an employer could do an investigation into an unfair labor practice, talking to the employee, but giving the employee essentially telling the employee up front that it was a voluntary participation in the investigation, nothing bad would happen to the employee. And now the NLRB wants to make it even more difficult for an employer to conduct an investigation into claims of that the employer violated the National Labor Relations Act. Other areas, and I'm just going to touch on a couple here. Weingarten rights. So what is that? If you're a unionized employer, you know what that means. A Weingarten right is where an employee can ask for their union steward to be present during an investigatory interview that is likely to lead to discipline. Years and years ago, non-union employees had the right to request that an employee, a coworker, be present during an investigatory interview that could lead to that employee's discipline. And that line of cases was reversed quite some time ago. The NLRB now wants to revert back to allowing non-union employees to have the right to asked for one of their coworkers to be present during an investigatory interview that's likely to lead to discipline. And of course, the current administration seeks to expand that which is considered protected activity under the National Labor Relations Act, and also seeks to provide greater protection to unauthorized workers. So where are all these changes coming from? Well, the changes, or the proposed changes, come from an individual who's referred to as the general counsel of the National Labor Relations Board. And she's the one that sets the policy. Her name's JenniferAbruzzo. She was sworn in last summer for a 4-year term. And I think what you need to know is prior to joining the NLRB last year, she spent a period of time working for the Communication Workers of America Union on strategic initiatives. She also spent some time 20 years with the National Labor Relations Board. But essentially, her office is responsible for investigating and then determining which unfair labor practice cases to prosecute. She has been described as being the most pro-union general counsel in the history of the National Labor Relations Board. And some of her policies certainly indicate that. And without going into extensive detail, she's issued quite a few memos outlining her priorities and what she seeks to address during her 4 years as general counsel. And you can see that she's going to be looking at seeking 10J injunctive relief. In essence, if somebody is unlawfully terminated, or they believe that the individual has been unlawfully terminated, rather than having a hearing before the NLRB will seek injunctive relief in federal court. And we're already seeing some of these cases being brought in federal court as it relates to the union organizing taking place with Starbucks and where employees have been terminated. Just 2-3 weeks ago, she announced her position that she was going to pursue cases that would essentially ban employer captive audience meetings during union organizing campaigns. And I think this is extremely important for you to understand, because I think this gives you an idea of her mentality. But a lot of employers, if they go through or are going through a union organizing campaign, it's not uncommon for employers to have meetings with their employees. And in the meetings with the employees, they inform the employees what's going on, what the union organizing means, and they explain to the employees or educate them with what it means to belong to a union, whether it means paying union dues, telling them that by joining a union, you're bound by a union constitution and bylaws. And employers will spend a lot of time educating employees in what are referred to as captive audience meetings. And so employers use that to educate employees so that they can make an informed decision on whether to vote for a union or not. And Ms. Abruzzo has announced that her office seeks to make that unlawful, essentially shut down an employer's free speech rights, as well as running their business and having meetings with their employees to talk about these issues. So as you can see, she's been very aggressive, and I think you can expect that her office is going to be very aggressive in enforcing and trying to change the laws in favor of unions. There's a few cases that may be of interest. There are claims, and this goes to an employer's free speech rights, but there were cases where that involved the Home Depot and Whole Foods, where employees showed up to work wearing Black Lives Matter face mask and other similar attire. And of course, the Home Depot and Whole Foods said that's against our uniform policy, and it's also offensive to our customers or certain portions of our customers. And so we're asking you not to wear these masks. And in some instances, as I understand it, employees were disciplined as a result of continuing to wear these face masks. And those cases now are pending before the NLRB. And you can see in one instance, there's a case that's going to go to a hearing involving the Home Depot that is here in Minneapolis. And in another case in San Francisco, the employer is trying to get the charge dismissed, but that's certainly likely to go to a hearing as well. But you can view this as a free speech issue, both from the employee perspective, but also from the employer perspective. And really goes down to, does the employer have rights to protect its business when they see that employee speech may have a negative impact upon the company's business. Another thing is the NLRB, the Department of Labor Wage and Hour Division, entered into a 5-year memo of understanding where they are essentially sharing information. They're going to be involved in joint investigations. They're going to be involved in joint enforcement activity. The bottom line is, what does this mean? It means that any information provided to the National Labor Relations Board will be provided to the Department of Labor Wage and Hour Division, or vice versa. So as an example, if you have a wage and hour investigation that's going on, and the investigator sees it as some of your conduct may have interfered with employee rights under the National Labor Relations Act, you might see a charge being filed with the NLRB, or vice versa. If the NLRB is investigating something and they see a potential wage and hour investigation, they very well may share that information with the Wage and Hour Division, leading to an investigation. So bottom line is, keep in mind that if you are involved in an investigation involving one of these two agencies, it is possible that you might be involved in the near future with the second agency because of the information sharing. All right, COVID updates. I'll cover this relatively quickly. Of course, the White House had its National Preparedness Plan that was issued some time ago. And in essence, when they issued that plan, it had 7 goals: restore trust, make sure that there's safe, effective, comprehensive vaccinations. They wanted to mitigate the spread of COVID, provide for emergency relief, ensure that the businesses were safely reopened while protecting the workers, and of course, protect the most that were at risk, and restore the U.S. leadership globally and be better prepared for the future. So that was Biden's 7 plans when he issued his executive order. And as you know, when he issued his executive order on COVID, there were a few that he issued. One was that employers with 100 or more employees were required to make sure that their workers were vaccinated or tested weekly. And of course, as part of that, he also was directing OSHA to issue an emergency temporary standard, which was in fact issued, and we'll cover that as well. And then he issued an executive order that essentially said on-site federal contractors and federal employees needed to be vaccinated by November 22nd. And there was an injunction that came into place there as well. So what happened? Well, as you know, OSHA, after the executive order was issued, OSHA adopted its vaccination and testing emergency temporary standard. The Supreme Court held that OSHA exceeded its authority in January and essentially stopped the emergency temporary standard from being enforced. So January 26th, OSHA withdrew the emergency temporary standard. Now, here's where I think some employers think that they're out of the woods. Keep in mind that although OSHA withdrew the emergency temporary standard, they did not withdraw the standards from the proposed rulemaking process. And so OSHA is still moving forward with a proposed rule addressing COVID. And although it seems to be focused on healthcare, it is going to be, I think when it comes out, it's going to be broader than just healthcare. It's going to impact all employers. So keep in mind that while the emergency temporary standard is unlawful, we still have this proposed rulemaking that's pending. And the proposed rulemaking still requires all employers with 100 or more employees to mandate vaccinations and or testing and masking. It does not, at least as it's proposed, does not, or I should say it does exclude workers who work at home or work outdoors. The proposed rule still has requirements that the employer would have to pay employees for time off to get vaccinated and pay for any sick leave as a result of any adverse consequences of having the vaccination. Bottom line is we're waiting to see what happens with this proposed rule. It hasn't come out yet. I certainly expect that there's still going to be challenges to that rule when it comes out as a final rule. But I would certainly make sure that somebody within your organization is monitoring the status of the proposed rule so that you're not surprised if and when it is finalized. In Minnesota, with regard to the OSHA emergency temporary standard, as you know, Minnesota adopted the emergency temporary standard verbatim. And as soon as federal OSHA said that they're not going to, that they're withdrawing the emergency temporary standard, they're going to do the same that they withdrew. Of course, if the proposed COVID rule is finalized from a federal level, Minnesota has also made it very clear that they will follow whatever the final rule is. And they're required to as a state plan. Minnesota as a state plan, anytime the federal government comes out with a new standard under OSHA, Minnesota is required to adopt a standard that is at least as stringent, if not more stringent. So expect that we're going to see a rule covering COVID. I think we'll probably see something this summer, if not sooner. But in addition, also keep in mind that OSHA and MinOSHA, they have the ability to cite you under the general duty clause, which essentially says that employers have an obligation to keep their employees free from a recognized hazard. And if you're not keeping your employees free from a recognized hazard, MinOSHA or the federal government can issue citations against you. And they have been doing that on a national level as well as within the state of Minnesota, where employers have been cited for general duty violations. Another thing for Minnesota employers to keep in mind is that as effective at the beginning of this year, if you weren't, you are now required to provide nursing mothers and lactating employees with paid breaks for the expression of milk. And that continues for 12 months following the birth. Additionally, if a pregnant employee comes to you and says that they need more frequent restroom breaks, they need to take additional food and water breaks, or they need to sit down, or they can't lift more than 20 pounds, they do not need to provide you with a doctor's note. The law essentially says that it is assumed that if they request that it is coming from a doctor. So bottom line is most employers, at least in my experience, are providing employees, pregnant employees, with accommodations, and those pregnancy accommodations now automatic under state law. So a couple things from a federal legislation standpoint. Things that may happen, and we'll see, is we do know that the Democrats in Congress and Biden are supporting what's referred to as the Family and Medical Insurance Leave Act, or the Family Act. And the Family Act would essentially provide paid leave benefits to all employees. And employees would essentially get up to 66% of their wages, capped at a maximum amount of $4,000 per month, for up to 20 caregiving days per month and up to 60 caregiving days per benefit period. And the paid leave available under most conditions would apply as addressed under the Family and Medical Leave Act. And the proposal is essentially that the Family Act would be paid by a payroll tax, which is paid by employees as well as paid by employers at 0.2%. What we don't know is necessarily how short-term disability policies will be impacted. They're leaving that more for a new agency to address how that would be addressed, but essentially they would attempt to coordinate short-term disability policies with the Family Act paid benefits. With regard to PTO policies, many of you have paid time off policies, which essentially say if you're going off on FMLA, you're going to be forced to use your PTO. And employers do that for a variety of reasons. One, they don't want somebody to be off for 12 weeks and then return and then take a 4-week vacation. And so employers oftentimes will force employees to use their paid time off so that when the employee is able to return to work, that they will actually perform the work that's needed to be done. Under the Family Act, essentially, they're not going to allow employers to force the use of PTO. So if this, it's a bill right now, but if this bill makes its way through Congress, it will ultimately be signed off on by Biden. And this bill is very similar to the California Paid Leave Act and could be very cumbersome for employers. So it's something to keep your eyes out on. Additionally, many of you have probably heard of the ProAct, but I would guess that most of you have not heard of the ProAct. And the ProAct is an acronym for Protecting the Right to Organize Act. And the ProAct has some of the most significant changes to the National Labor Relations Act that we've seen since the National Labor Relations Act was adopted. Essentially, what the ProAct seeks to do is adopt what's referred to as the card check. Many of you probably remember when President Obama was trying to adopt card check as a law. Essentially, if a majority of employees signed a card and those cards were presented to the employer, they had to automatically recognize the union as a representative of employees. I'll tell you, as a practitioner, that's something that I don't agree with, because I've seen a number of cases where employees have been harassed to sign cards. They were told the card was more an information card, not a card where they were agreeing that the union would be their representative, or the union had told them that, look, it's only so we can have an election. You can always change your mind. And the card check would still allow the unions to misrepresent the nature of the cards, but it would make it easier to get their foot in the door with an employer. couple other things that I'll focus on as it relates to the ProAct, and things that may be of interest to those that are on the line. With regard to the ProAct, one of the most concerning aspects is that what the federal government would seek to do is require mandatory mediation, where a federal mediator would decide what is in the best interest of the employer as to what should be in a collective bargaining agreement with their employees if the union and the company were unable to reach an agreement within the first 90 days of negotiating a first contract. So think about that. The federal government would decide for you as a business owner what's in your best interest. Other aspects of the ProAct is there would be a significant increase in fines for employers who engage in unfair labor practices. In fact, right now, employers can't be fined if there's an unfair labor practice, and this law or this bill, if it became law, would essentially allow the NLRB to issue a fine to employers up to $100,000 if they had violated the National Labor Relations Act repetitively. Similarly, some of you may remember under the Obama administration, they sought to prevent employers from seeking advice during union organizing campaigns, where essentially the Obama administration said that if you seek legal advice, if you talk to an attorney about how to address a union organizing campaign where the attorney is advising you on what you can say, you can't say, what's lawful, what's unlawful, or the employer provides supervisors with training, that you would have to disclose that to the federal government. And not only would you have to disclose that to the federal government, but the attorney would have to disclose that to the federal government. In essence, you'd be waiving the attorney-client privilege. And in essence, you'd also have to disclose what you paid that attorney for the services that they rendered, which is very scary, right? Because when you seek advice from an attorney, you expect that information is going to remain confidential and nobody's going to know about it. And the Democrats that are pursuing the ProAct are essentially saying, no, you have to disclose that information to the federal government, where that information would then be available to the general public. So the ProAct is extremely concerning. Most would say that the ProAct probably won't pass through Congress in its current form, but certainly a lot of folks who are watching this bill believe that there are aspects of it that may make its way through and become law. So some very concerning issues. Another recent development is President Biden signed a bill last month, which essentially prohibits mandatory arbitration for workplace sexual harassment and sexual assault claims. So if you do have employees who sign off on mandatory arbitration agreements as part of their employment, your arbitration agreements should be updated to make it clear that sexual harassment or assault claims are not subject to the mandatory arbitration agreement. Otherwise, your entire arbitration agreement could be deemed invalid. So last topic is on non-solicitation and non-competition agreements. As I said before, I have seen a significant uptick in enforcement actions related to non-compete agreements. And that shouldn't surprise anybody on today's webinar, because as you know, it's a very tight market for employees. And of course, it's an employee market where employees will move from one job to the next and get significant increases. And oftentimes those employees who are moving have a non-compete agreement or a non-solicitation agreement, which the former employer seeks to protect. So, you know, a non-compete agreement essentially is it protects the employer in the event the employee leaves and tries to unfairly compete. And so a non-compete is generally geographically in scope. So you might have an employee that signed an agreement that they won't compete within the Southern County area of the Twin Cities, and that would be considered a non-compete. Whereas a non-solicitation agreement is where the employer agrees, assume that they're a salesperson, they agree that they won't solicit the company's clients whom he or she served while working for your company, or they won't solicit the company's employees. And I'll tell you that courts would much rather address a non-solicitation agreement than a non-compete agreement, because where courts get concerned is whether an employee, when they leave and an employer tries to enforce that non-compete, one of the things they look at is this reasonable? Is it reasonable to the employee who left the company? And so I've had cases where the employer had a nationwide non-compete and the employee had spent 20 years performing work only in Minnesota. And the court may look at that and say, look, you know, you might have a legitimate basis for precluding somebody from working in Minnesota, given the unique nature of this business. But to say that they can't go work in another state where they have no relationships in that other state, and you as an employer have no relationships in that state is not reasonable. So as I said, courts would rather focus on non-solicitation where an employee won't solicit certain customers. A lot easier for courts to understand why such an agreement is reasonable and necessary. And of course, when it comes to a non-compete agreement, they should have confidentiality provisions built in where the employee agrees that he or she won't divulge or use company confidential information after they leave. So the bottom line is, when it comes to a non-compete agreement, they should protect a legitimate business interest of the employer. Customer relationships are very clear. With regard to a non-solicitation agreement, some things that employers need to think about, which they probably haven't, and that is, what do you do with regard to social media, and who owns the social media and the contacts that are generated under social media? And the ideal, or the classic, I should say, is LinkedIn. So you have a salesperson who works for you and they're on LinkedIn, and through LinkedIn, they link in with all of your customers and your customer contacts. They leave and they go work for a competitor. Well, who owns that LinkedIn contact database? And so from a non-solicitation agreement or a non-compete agreement, I think you need to start thinking through who owns that social media and what they can do with that social media. So with their non-compete, something to think about. Your non-compete agreements should protect goodwill, which they generally do. They should protect confidential information, which they probably do. And then in addition, what we like to do as attorneys with our firm is ensure that there's a reference to the Minnesota Uniform Trade Secrets Act or other states, as well as the Defend Trade Secrets Act. And in particular, if your non-compete is referencing the Defend Trade Secrets Act, which is a federal law, and it's referencing it the right way, it gives you an option to go into federal court versus staying in state court. And there are a lot of things that you have to decide as far as whether you want to be in state court or federal court, that you'll need to confer with your legal counsel. But as a firm, we like to build in the Defend Trade Secrets Act into non-competes to ensure that our clients have options on how they would pursue a non-compete if it's breached. And the last piece to keep in mind with non-compete agreements is, in this competitive market, I know that there's a lot of companies out there that don't have non-competes, but they're starting to think that they need to have them in order to protect their business. And if you're going down that thought process, you have to be careful based on the state that you live in or that your business is in, because in particular, as an example, in Minnesota and a lot of other states, continuing employment is not sufficient consideration for signing a non-compete. So if somebody is going to be hired to join your company, that individual should know prior to commencing employment that they'll be required to sign a non-compete agreement before they sign, and ideally they get a copy of that non-compete before they begin. Because if you present that non-compete for the first time, the day that they commence employment, a court in Minnesota, as well as in a lot of other states, will say that non-compete is invalid and it's unenforceable. So that's one thing to keep in mind. And two, if you're deciding to institute non-compete agreements within your existing workforce that employees have not signed in the past, it has to be accompanied with additional consideration. And so that additional consideration, it has to be something that they're not otherwise entitled to. And so I think the best way to do it is to make it clear that it's a signing bonus for signing the non-compete. And, you know, questions are often asked, well, how much is enough to show that there's consideration? And I would say work with your legal counsel with regard to what amount you want to use. I mean, you certainly could have an amount of $250. You could have something $500 or something even less than that. That forms consideration for a non-compete. But the bottom line is, if you have somebody signing a non-compete after their employment has commenced, in Minnesota and a lot of other states, it's a really good practice to build right into the non-compete that they are getting additional consideration beyond just continuing employment, and building right into that non-compete agreement what that consideration is. Last comment I will make with regard to non-competes, I have a lot of clients who will tell me, well, non-competes they're not worth the paper that they're written on. And that is not true. If they're well drafted, they are enforceable, and the courts will enforce them. And I have enforced quite a few non-competes during the course of my career. So that's a lot of information in a short period of time. I promise to leave a few minutes for any questions if you have any. And Chris, I am not seeing any questions. I don't know if you're seeing any on your end.
I have not seen any questions in the chat or Q&A. So I think at this point, I don't know if anybody you've asked wants to raise their hands or stick around. I will say that we have recorded this session. And so what we'll do is we'll make the specific edits or kind of clean it up, and we'll send that out probably by tomorrow at some point. And if there isn't anything else, we want to thank Tom for his amazing information, although it was a lot to take in. That's why you can keep going back and reviewing. I know that Tom is an expert, and it seems that he provided his phone number and email for you. And anytime you have questions, I know he's very receptive at responding. So thank you so much, Tom.
Yeah, thank you, Chris. And thanks to PIM for having me.
Yeah, we'll probably be having another Smart Cafe in July. It will be that last Wednesday in July, and most likely it will be on some workforce development information. We just had a white paper, and the person that produced that white paper will be doing a panel. And so that is the plans for July. And hopefully we'll see Tom again in the future.
Thanks, Chris.
All right. Well, thank you, everyone. Have a great day, and we'll see you at the many upcoming events that we have.